Good morning. Welcome to the Court of Appeals. Our apologies, we are running behind schedule. Our morning argument was one full of questions that took us a little past the scheduled time. So that is the explanation for why we have gone past our start time here today. We are here in two cases, both in re IC. If I could have counsel make their appearances, please.
Alexander Marshall for MC, and I will also be arguing for the mother AMC. And I have Emily Adams, who is AMC's counsel.
All right, very well, thank you.
John Peterson, Assistant Attorney General for the State of Utah.
Mr. Peterson.
Good morning, Your Honors. He back with the Office of the Guardian ad litem.
All right, thank you. So I want to just confirm our schedule, since this is a little bit of a unique situation where we have two separate cases with separate parties, but we're briefed very much together. So as I understand, what has been agreed upon by everyone is that the appellants, both MC and AMC, will be argued together by Ms. Marichal, and that would be 30 minutes of total time, and you're reserving 10 of those minutes. Do I have that portion correct?
That's correct.
All right, and then on the appellee's side, we have both the state and the guardian ad litem. I understand that you will be taking what is your collective 30 minutes and will be splitting it evenly down the middle. Is that correct?
Correct, Your Honor.
All right, and then the guardian ad litem will be going first. Is that also correct?
Yes.
All right, I think we're all on the same page, and so with that, we will turn the time to the appellants.
Thank you and good morning. This is an unusual case that tests the limits of the Utah Code. But before getting into those technical details, it is important to remember that the point of these proceedings is to serve the child. And the child here, it is undisputed, viewed MC as her father, his wife as her mother, and had a significant enough relationship with her birth mother in Mexico that 18 months after being removed, recognized a photo of her and named her by name. With that in mind, this court should reverse for two broad reasons. First, there were no grounds to terminate the birth mother's rights. And second, the juvenile court should have recognized MC as the child's legal father because he is listed as the father on an authenticated, valid Mexican birth certificate. While these issues are heavily interrelated, this court can reverse as to either or both parents. The simplest path to reversal is to hold that the Mexican birth certificate should have been recognized as proof of parentage, at least in Mexico at the time that the birth mother turned over custody to MC.
Can I start you there?
Absolutely.
As I understand it, the controlling provision of Utah laws is the provision from the UCCJEA that turns on whether this Mexican birth certificate should be recognized as a child custody determination. Do I have that right?
You do.
Okay. You know where I'm going. The definition statute says that a child custody determination is, quote, a judgment, decree, or other order of a court providing for legal custody. And what they're telling us in response is that it's that last phrase that matters here, order of a court, that because a Mexican birth certificate is not an order of a court, it just simply doesn't qualify, full stop. Why are they wrong on that?
So most of the reason why, well, there's two reasons. First, it creates this absurd situation where there's no mechanism to recognize a foreign birth certificate. And as we laid out fairly extensively in the briefs, that causes a situation where the parentage of anyone with a foreign birth certificate setting foot in the jurisdiction of Utah has no legal parents. So this creates just a whole quagmire of legal problems.
Let me actually jump in there. How is it different than a birth certificate from, let's say, Georgia or North Carolina? Because those likewise are not a judgment, decree, or order of a court. So isn't the Mexican birth certificate simply the same as any other state's birth certificate? Because the UCCJEA is about custody, right, and custody rights and determinations. And what you see in those are orders from courts, a divorce decree, that set forth the parentage custody arrangement, right? So if someone came to Utah with a birth certificate from Georgia or North Carolina, it's putting them in that same spot they're in as if they were from Mexico, right?
The only difference is that the Parentage Act, and this kind of jumps around, has a full faith and credit provision that would probably apply, and I have to go back and look at the exact language, but would probably apply to other states. And I believe the juvenile court even talked about this provision because she differentiated between the states as outlined in UAPA, the Parentage Act, and another sovereign like Mexico, and determined those are not the same thing, and so she doesn't have to apply the full faith and credit from the Parentage Act to the birth certificate. So that's why we're talking about UCCJEA and why that seems like the best place for a foreign birth certificate to fall, because the UCCJEA is designed to deal with foreign countries in addition to states. There's specific provisions in the UCCJEA talking about international application, which just doesn't exist in the Parentage Act.
Right, but again, those are in the custody arena, right? I
Right.
mean, the UCCJEA is to enforce, if I have a divorce decree from Portugal and it's not being followed here, then I can take that document to a Utah district court and say, here, this is my right to custody, and I want you to enforce it, and the UCCJEA permits that to occur. So I appreciate that it has these international implications to it, but we're just not on two squares here, right? It doesn't line up.
Yeah.
And there, as I understand it, there just isn't anywhere that addresses this circumstance where the only thing that the MC has in this case is a Mexican birth certificate.
Right.
Right.
Yeah, so there, you're exactly right. There is this gap. We have a gap in the statutes. We have just nothing that really applies directly on all fours. So we have to choose something, because it can't be that nothing applies. It can't be that we just don't do anything with foreign birth certificates. And so our argument is that the gap should be resolved in favor of the UCCJA applying in terms of considering the birth certificate a child custody determination in the cases, and it's a narrow holding, in the cases where, under the laws of that sovereign where the birth certificate is coming from, the birth certificate confers custodial rights.
Well, the problem we have here, though, is that we have an American who has his name put on the birth certificate in Mexico and has a pathway to get proper documentation to the United States, goes to the consulate in Mexico and could obtain the proper paperwork to do so. But the consulate, for whatever reason, says we want genetic testing to demonstrate this is actual parentage. I don't think we know in the record why they wouldn't give the paperwork without it. But MC and AMC decide not to even try. They don't comply with that. And so it's not that there isn't any path, it's that MC chose not to try to take that path, and we all know why he chose not to take that path, because the genetic testing shows he's not the biological father. And then it's a step beyond that. He comes to the United States and he falsifies records with the state of Utah to get a birth certificate in Utah. So this isn't a situation that seems all that sympathetic, where we have a situation where we have the biological parent in Mexico who has just no options available, and there's this gap in the law that leaves this biological parent without the proper rights and proper forum and a way to pursue them. We have someone who's affirmatively trying to not only skirt the law, but fraudulently obtain documents that he's not entitled to. And so I guess at the end of the day, while I appreciate that there might be a gap here, it seems like this isn't the case where we say, oh, we've got to fill in the gap because there's this great compelling reason to do so.
So a couple of responses to that. One thing I think is useful in thinking about this is what could have been just a little bit different. So had MC and AMC, for example, done everything exactly the same, but before going to the consulate, they had gone to a Mexican court and gotten just a plain custody order that says he has custody of the child and she's going to have weekly video visits. And a Mexican court had issued that order. And then they'd done the exact same thing that happened. They went to the consulate, and the consulate, because they're concerned with immigration, not necessarily with parentage, in fact, their really main concern is whether there is a child born on U.S. soil or whether they are blood related to an American citizen, because that's what they care about for citizenship. We're not arguing citizenship, we're only arguing legal parentage. But if they had done everything exactly the same, and he had still forged the birth certificate and everything else that still happened, we wouldn't be here. Because that would be a child custody determination.
I appreciate the point you're making, but there sort of seems to be a subtext to the way that you phrased that or discussed it, which is that would have been something of a ministerial, or sort of course they could have gone to a Mexican court. But I think what we're hearing from the other side is that step matters. That's the very reason that the UCCJEA has that phrase, order of a court, is maybe we can operate on, maybe it's a faulty assumption, but we can at least operate on the assumption that if you go to a Mexican court, the Mexican court is going to do something a little bit more probing than the hospital or whoever it was that issued the birth certificate is going to do. That step gives us a little bit more assurance that everything's on the up and up. Why is that the wrong assumption? Because that's the point that I took from the GAL in the state brief.
Two reasons. The first one is that the process to get a Mexican birth certificate, as they laid out through Mexican lawyers testifying at trial, is a little more rigorous than just putting the name on there. They have to testify, swear under oath in front of a magistrate, very similar to the VDP process, which is why we make that alternative argument. So if a Utah court would have done exactly that. If this had all been in Utah and he had signed a VDP, it would have required pretty much the same amount of verification as what happened in Mexico. And he could have gotten a custody order, and that would have undisputably been parentage. So in either country, no matter what, there wasn't really another step that had to happen. I mean, people don't have to take a DNA test to prove legal parentage. That's just not the way Utah statutes work. It's not the way Mexican statutes
But
work.
if you do a VDP in Utah, the statute requires that you file it with the Office of Vital Statistics, right? It has to actually be presented to the government. And there's a specific form that's required. And I understand you to be asking us to basically accept what was done in Mexico as the VDP. And I'm just wondering, how do we have the authority to do so, right? It doesn't meet the requirements of the statute clearly on its face because it's not the Utah form, it's never filed in Utah. And so what would we be relying on to say, yes, this Mexican birth certificate is equivalent to a VDP sufficiently such that we're going to just decide that statutory requirements aside, we're gonna call it a VDP and proceed as if it is one?
So I just want to be very clear, this is only an alternative argument to the first
Understood.
one. But the way we could do that is because it would have been impossible for him to file a VDP. You can't file a VDP with a foreign birth certificate. So there was no avenue for him to have filed a legal VDP in Utah. Otherwise, that would have been a lot easier. It's just not allowed by our statutes. Again, we have a gap. So whichever path we choose, we end up with this gap in the statutes that creates this problem where we just don't know how to treat a foreign birth certificate when it comes to challenging parentage in the first instance in Utah.
Yeah, so let me stay there on the structural levels. I understand sort of how you're framing the problem for us. It's this. There's a gap in the statute about what to do with these foreign birth certificates. To fill the gap, we're going to use the UCCJEA, but then when we use the UCCJEA, we're going to excise from it that order of the court language. And if we do that under an absurdity principle, as I've dug into the absurdity cases, it's not a small hurdle to do what you're asking us to do under the absurdity canon. It requires us to conclude that no rational legislator could have meant this thing, meant for it to be applied in this way. And this comes back to the question I asked earlier. Why couldn't the legislature rationally think, rather than doing this on a country-by-country basis, rather than asking the appellate courts to figure out what Mexico requires versus what France requires versus what Japan requires, we're just going to say as sort of a global rule, you've got to go to a court, and that's what's going to assure us, the people of Utah, that everything was on the up and up. Why couldn't a legislator rationally think that a court order is the thing that makes this safe?
So a couple of responses to that. A rational legislature, reading the statute, I would say this just wasn't a contemplated scenario. Like, it wasn't contemplated that this is the kind of situation that would come up, because the UCCJA, as Judge Oliver pointed out, is generally for custody disputes across country lines, and that's what it was designed to do. It wasn't really designed to settle these parentage disputes over sovereign lines. That's a completely different issue, but there is really no statute that does that, federal or state. I would point the court, for the absurdity doctrine omission problem, I would point the court to two cases. One is Davis v. Purdue Pharma, 2020 Utah 17, where Justice Lee wrote that not every gap in the law is a purposeful omission. Some gaps are just gaps to be filled later as by the exercise of common law power or the inherent power of the court. So just because we have an omission of birth certificate in a child custody determination, that doesn't mean that that was on purpose, and we should be strictly
I
adhering to
totally
that.
take that point, but if you're asking us to apply the UCCJEA, it feels like you have to take the bad with the good. I mean, the very statute you're asking us to apply has this language which just cuts directly against you. And it'd be one thing if you're asking us to sort of conclude under some sort of common law residual authority that this is what we think the answer is. But if you're pointing us to a statute and the statute's got language, then now we have to grapple with that line of cases, I think, don't we?
So I don't think you need to read out or other order of the court, and this is the second reason I think it's okay, is because a birth certificate is the end result of any order of the court adjudicating parentage. So it's kind of like you just got the end product of the order of the court. So if his parentage had been adjudicated in Mexico for some reason, it would have resulted in him receiving a birth certificate. If it was adjudicated in Utah, it would have resulted in him being put on the birth certificate. It is the end thing that results from the order of the court. So I think this court can attach it that way and say that it encompasses what is the end product of that exact proceeding.
But the end product of the UCCJEA is not a birth certificate.
No, of any sort of proceeding adjudicating parentage that would be an order of the court under the UCCJEA would result in a birth certificate.
I don't think that's fair, though. I think you're going to have a divorce decree, and it's not going to have a birth certificate in it. It's going to have a decree of parentage, and it's going to have parent time and a provision of which parent receives what parent time. A birth certificate's totally tangential to that. It probably never even appears in the proceeding before the district court.
Not in a divorce, but if, say, we were just adjudicating parentage in the first instance, like not a divorce, just adjudicating parentage, the end result of that would be an order saying, your dad, and your name is on the birth certificate.
And you get this parented right? It's a custody determination.
Right, and that's why it's important that the Mexican birth certificate under Mexican law confers those custodial rights under Mexican law. That's why that is a key point. This is not a broad holding of any birth certificate falls within the UCCJEA. It's very narrow. It has to be a birth certificate that by the definition of the country that issues it, issues custodial rights with it. That's the
But we
Patriot
have
Protestus.
to read that into the UCCJEA. We have to read that in. That doesn't say that anywhere. It doesn't say if you are coming from a country that has these additional rights that attach to a birth certificate, then you don't need an order or a decree. All you need is the birth certificate. I mean, that's nowhere to be found, right? So we'd be reading that in.
It's more because the definition of child custody determination is talking about something that goes to the custody of a child, right? That's the substance of the definition. Then we're just taking the substance of the birth certificate under Mexican law, and it could be labeled anything, but the substance is he gets custodial rights because of that certificate.
So in theory, if there was country X, Y, or Z that only issued birth certificates after there was a court order, you're saying that's the interpretive step that we should take, and you're
Yes.
saying we should essentially regard what's happening in Mexico as the equivalent of that, right?
Yes, and it's not totally far-fetched, because again, they did have to go before a magistrate. This wasn't just filling out a form at the hospital and that was it. They had to go before a government official and swear that he was the father. This is a quasi-judicial step, so it's not that we're opening this door to kind of any sort of certificate that's issued being able to be used under the UCCJEA. This is a very specific and narrow holding under the facts of this case. This court could just limit it to the facts of this case if it was really perturbed by how broad this could get, but it has to do something with this birth certificate. Otherwise, we're just saying that no birth certificates are ever recognized under Utah parentage laws, and that just can't be right, because even the Guardian admits in a footnote that would mean that anybody that has a foreign birth certificate has to somehow adjudicate it in Utah in order to
Isn't the
have
problem
parentage
here,
rights.
though, that he has a birth certificate, but he's not genetically related to the child? Because in any other circumstance where someone has a birth certificate and they come in and there is a parentage action and they do genetic testing, it's going to match, and so all is well and it's over and done with. And so the real problem here is that there is no biological connection between the person whose name is listed as the father on the Mexican birth certificate, right? I mean, that's really the issue here. I think it's not a broader issue of saying you couldn't ever establish parentage with the birth certificate. Sure you could. You could come in and that's a starting presumption, but we have genetic testing available. It happens all of the time, right, to confirm that. And it's just happens that in this case, it can't be confirmed because there's no biological relationship.
But you first have to go through that process. Even if you are biologically related, you would still have to go through that court process to establish parentage, which in itself I think is a burden enough to be absurd. There's no way that legislators thought that we should have to do that with every
Well, here's the
single
question.
person.
What are you establishing parentage for? I guess is my question. What would cause you to have to go to court to create this, to establish the legitimacy of your parentage?
If DCFS comes and takes your child. That would be the most obvious reason. There might be
Right.
others, there might be other like weird scenarios.
Right.
But even
That
biological.
that doesn't seem to be too onerous of an obligation. If DCFS comes in, they have good cause to come in and get involved with the child. I mean, well, they're required to demonstrate that. To assure the court that the people involved are who they say they are and have the rights that they say they are. Genetic testing is required. That doesn't seem too onerous. That doesn't seem like a big policy concern, right? We want to make sure you have the right people.
That, in most cases, that's right. But you do also have foreign adoptions. Those people are not biologically related to their children, but they're very much their children. They shouldn't
Right,
have
and
to come into a Utah court and prove that they're legally the parent of their child when nobody else has to. It's just because they come from a foreign country. That just, it does seem to create this absurd situation. Although there's solutions to it, the situation is not intended to exist that way. And before I run completely out of time, I do want.
Before you go there,
Yeah,
I just,
okay.
while something's on my mind, I'm sorry.
fine.
I just want to make sure that I'm sort of teasing this out correctly. If MC ends up prevailing on his issues, what happens? So what we'd be saying is that the juvenile court should have treated the Mexican birth certificate as what, I'm not going to be able to fill in the blank correctly there, as the equivalent of a declaration of paternity, right?
That's the alternative argument. The primary argument is it just shows that he was the legal father in Mexico.
That it establishes his paternity, so then in theory, DCFS can still come in and do to him what they've done to mother, which is file a petition to terminate his parental rights.
Yes, that's what they should have done.
That would be the next step
Mm-hmm.
in this, but that's not before us, the implications of that.
Exactly, and that's really all that we're trying to get is just let him have the full proceeding. Let him have the full proceeding as the father. He's de facto the father. No one's disputing that. This child certainly thinks he's the father. And he is legally the father in Mexico, which goes to mother's grounds that even, first and simply, the Child Custody Transfer Act wasn't enacted when this transfer happened. So it just cannot apply. By its own plain terms, it has a statute, or it has a provision that doesn't allow it to apply retroactively.
I know I keep taking you, Phil.
Yep.
Should we certify that question? This is one of the things
Sorry, which one?
The question as to MC. If we've got this true gap in Utah law, and it would require us, in theory, to go, if we go your way, it would require us to not only incorporate a statute that doesn't directly speak to the issue, but then to either excise a phrase or at least change its plain meaning, I would think. Should we be doing this, or should we send that to the Supreme Court?
I mean, you certainly can do it. I won't tell you which one to do.
I was a little bit surprised reading the briefing that there hadn't been a request for this along the lines from somebody.
To be completely candid, it took a lot of figuring out to get to this point because it's such an unusual situation and it's instinctively wrong because everyone's sitting here going, but he's the dad in Mexico. Mexico thinks he's the dad. Mexico came in and validated this birth certificate and said, yep, he's the dad. So why isn't he the dad here? And that's the question that just never had a satisfying answer. And this is the most satisfying answer we could come up with that both serves the purpose of these proceedings to get at what we should do with the rights of parents, even if they're not biological parents, when they are de facto parents for this child. That's the point. And
Well, and it does seem that if we do make a decision and one of the sides disagrees with that decision, which seems likely since both sides can't win, either side could.
I wish we could.
Either side could
So
simply file the petition for cert
Right.
and ask the Supreme Court to take it. I do see that you're out of time.
We haven't gotten to the mother issues. Let's get to the mother
We
issues.
were asking questions is the reason, and part of the difficulty, I think, with this case being together is that mother and father are very differently situated with respect to their legal issues, or at least the proceedings that went forward. The facts are certainly the same. So in the interest of getting everything out on the table, I think, and I'm the chair, so I get to decide, I think, unless someone's going to overrule me, we're going to let you continue and address albeit briefly,
Yes.
the arguments for mother, and to assuage any concerns, we'll have the same level of flexibility for the state and the guardian ad litem, because I do recognize there just is an awful lot going on
There's a lot.
in these two cases. So with that, you may shift to the mother's case.
Thank you, I appreciate it. And this is much more straightforward, so it shouldn't, it's not quite as messy as the first issues. So the Child Custody and Transfer Act was not enacted. It specifically does not apply retroactively, so it could not apply here to be grounds to terminate mother's rights because she did not engage in an unregulated custody transfer. Now, part of this is made very simple if this court decides that the Mexican birth certificate at least shows that he was the legal father in Mexico in 2019. Because then she just handed her child to the father, which is absolutely not an unregulated custody transfer. But even if this court decides differently as to the birth certificate issue and decides that from moment one, he wasn't the legal father, even in Mexico, even though Mexico thinks that he is, it still can't apply this statute. So the only thing we're left with is this kind of very alternative ground of a possible abandonment. But even that ground was argued only in the context of the unregulated custody transfer. The state argued for abandonment via unregulated custody transfer. So abandonment was not analyzed as a standalone ground, and the ground
But
for
it was
abandonment-
analyzed entirely separately by the juvenile court, and the court went through all of the statutory factors in
Nope.
608.
No, so 608 is separate. 608 is about whether to disregard the genetic testing.
Oh, my
It did
apologies.
go through those.
Yeah, but there's a section, and let
At
me
the
see if
very,
I can
very
find
end,
it,
yeah.
on abandonment, that is separate from, as I read it, I mean, the act comes in, the Transfer Act comes in very early on, and that this was a separate abandonment analysis, starting on, this is a lengthy decision.
It really is. And there's two of them.
Here it is, 1632 of the record is where I have that AMC has abandoned IC.
Yes. and-
Right, and this here isn't referencing the act as I read it, it's referencing the controlling Supreme Court case law on abandonment. So is it your view that this was not an alternative holding, that this was somehow an extension of the analysis under the Transfer Act?
Yeah, so the first argument is that this is not an alternative holding because it's organized under AMC neglected IC. If you go back to 1623, the Roman numeral there is AMC neglected IC when she abandoned through an unregulated custody transfer. Then it goes through unregulated custody transfer, and sub C is AMC has abandoned IC. So it's continuing to talk about the unregulated custody transfer. It's just doing it as it's like a feature of the unregulated
But
custody
with
transfer.
citation to existing Utah case law that has nothing to do with the Transfer Act, right?
Yes, so that's more indication that it's not abandonment under the termination code, because what it doesn't cite is the termination code, the Termination Act. So there is a completely separate abandonment definition under grounds for termination that is not what is in the Supreme Court holding. They're two separate things. So under Utah Code 84-302, the state has to establish prima facie, that this is in the ground statute of the termination
Right,
act.
and isn't that the same, I mean, I know the statutes have been renumbered, and you all probably
not the same
know the
text.
renumbering differently than I. So what you're telling me is it's different than what was analyzed in let's see,
Yes,
in TE,
right, that's
which
correct.
is the case cited by the juvenile court in the footnote.
Mm-hmm.
Okay, so obviously that the statute didn't exist at the time of TE because that's from 2011,
And that's why that was there.
right? So.
So it was
So wouldn't that have a-
essentially
wouldn't the-
superseded by statute.
Except
This
that,
test.
except that you're arguing that the statute doesn't apply. So then the
The
case law
termination?
has to apply.
The Termination Act does apply. Sorry, I know there's a lot of statutes.
Okay, Transfer Act.
Transfer Act does not apply.
Not is what
That's a
you're
no.
talking about. Okay.
The Termination Act is the ground, that's the authority that the juvenile court has to terminate parental rights, which is what it's doing with mother, because she is definitely mother. We confirmed that one for DNA. So the juvenile court is terminating under the Termination Act in 84, 80 chapter 4.
80-4.
Yeah.
Right. Okay, so let's assume for argument, I understand you're saying that this is not an alternative holding, that this is part and parcel of the Transfer Act decision.
Correct.
But let's say for the sake of argument, because that's what we're here for, that this is an alternative holding. Why is it deficient?
So it's deficient because it doesn't go through the right burden shifting that happens in the grounds portion of the Termination Act. So there, the state has to establish a prima facie case of abandonment, and going through those factors, they haven't done that. And then even if they have done that, she rebutted it. So that is all on page 43 of our opening brief, and then kind of further on, we go through the factors of how the state establishes a prima facie case. So they have to have surrendered physical custody of the child for a period of 6 months. Following the surrender, have not manifested to the child or to the person having physical custody of the child a firm intention to resume physical custody or to make arrangements for the care of the child. She clearly made arrangements for the care of the child, so that one doesn't apply.
Forgive me if this question is a little bit afield, but I'm looking at the language there that leads into that list of factors under 80-4-302. And maybe I'm getting too particular about the verbiage, but let me just ask the question. So it says, in determining whether a parent or parents have abandoned a child, it is prima facie evidence of abandonment to the parent or parents, and then it gives the list of factors. I don't read that clause, it is prima facie evidence of abandonment, as saying that the state has to satisfy one of those. It seems to me on a plain language level to be saying if the state satisfies one of these, it's prima facie evidence of abandonment.
It shifts the burden, to the parent. This is just how the abandonment analysis works in juvenile court, is this has to be established first, and then the parent has the opportunity to rebut whether they abandoned the child. That's how this analysis is done
So
under this part of the code. There is no other.
You're saying there's no alternate common law test about what abandonment means outside of these factors?
Not that is used since this was enacted, no.
Okay.
So it had to, at the very least, the analysis is deficient because it had to follow these factors, and under these factors,
Okay, so let's take as a given that you're right, and if the state or the GAL think you're wrong about that, I'm sure we're about to hear about it. But the argument, at least as it was brief, seems to turn on 1A, which talks about whether the parent made, quote, arrangements for the care of the child. And I take your point of your version of the facts here, but one of the things I'm struggling with, though, on that is we have all these findings from Judge Eisenman, which seem to cut against that last phrase, to seem to cut against the notion that mother, quote, made arrangements for the care of the child. I'm looking 1602, this is within the findings of fact on the termination decision. And I'm looking at the various findings from record 1602 to 1603. For example, there's a whole bunch of them that go to this, but at the end of finding number 27, the last sentence, this makes the claim that they were planning to co-parent as a threesome less believable. She goes through all these things that she's finding undercut the notion that there was really an intended three-way parenting scheme. Just one more, and then I'll let you respond to it. At the end of finding 29, it carries over to page 1603 of the record. She says, because of the way that the visa and the immigration rules work, quote, it would be unlikely, if not impossible, for AMC to acquire a visa to travel legally to the United States. So it would be highly unlikely that IC would go to Mexico or that AMC would come to the United States. So we've got all these findings that seem to suggest that in Judge Eisenman's views, that's not what's going on here. That what was really going on was she just gave the baby away. So if that's so, don't you lose even under that provision of the statute? I know that was a long question, I apologize.
No, because the statute has two alternative things. It's either she wants to resume a parenting role and shows that she's going to resume a parenting role, or provides for the care of the child. It doesn't mean, she doesn't have to intend to resume a parenting role as long as she is providing for the care of the child, which is what she did. And I think this has to be viewed in the context of the circumstances.
So if somebody just says, I don't want to be mom anymore, I don't want to be dad anymore, and then they've got a cousin who says, yeah, I'll take the baby, but I'm moving across the country and I'm never coming back, and so the parent says, great, kid's yours. They've made arrangements for the care of the child, which is the statutory phrase that you're looking at. You're saying that's not abandonment?
It's not a prima facie case of abandonment. Especially not if they're keeping contact, which clearly was happening here. This child recognized her after 18 months of no contact, and she was a 4-year-old.
But the statutory phrase that you're hanging that argument on, I think, is to make arrangements for the care of the child. So you give a child away to somebody else. You say, this is your child, you promise to take care of the child, and they say yes. You're saying that's not abandonment because they've made arrangements for the care of the child. I mean, how could that be? I'm struggling with that.
So,
Well,
Sorry, I'm getting back to
that
that.
does
Go ahead.
happen. with a family placement, right? Single mom, 17, kind of in over her head, and entrusts the child to her older sister and aunt who lives in Colorado. That doesn't strike me as being a classic abandonment.
So I suppose that's why it mattered, that's where you were going with that. That's why it matters, the various facts about maintaining contact and so forth.
We have to allow in the statute room for alternative family arrangements because this happens. And it's not abandonment when she's making a very conscious choice, handing a child to someone who she believed at the time was at least the legal father, because that's what the Mexican birth certificate said. So she wasn't handing them to a cousin or someone random. It was someone that she knew who was there, who cut the umbilical cord, who paid for her pre-medical or prenatal care. Like, it's someone who was involved and there, and who she believed at the time was the legal father. And she made arrangements for that care because she couldn't do it. And she knew she couldn't. She had 5 other children. She's a single mother in Mexico. These are circumstances where she had to make a choice. And to say that she is abandoning her child to the point where she shouldn't even have parental rights anymore because she made that choice for her child, that is unfair. That is not what the statute is intended to do. And if the state wants to go back and prove abandonment,
But that actually happens all
it
the
can.
time. It's called an adoption,
That's right.
right? I mean,
Yes.
that's a very common proceeding, and that could have happened here.
Maybe. Yeah.
I mean, I don't know what the barriers to that were, but apparently there were enough that it caused MC to engage in illegal behavior to try and become the legal parent of this child. And I mean, the circumstances here, they aren't straightforward. And they aren't, like I said, this isn't really the most sympathetic case. I mean, you mentioned that the MC was involved in some prenatal care. They also lied and put the name of MC's legal wife on the ultrasound that was conducted in Mexico. I mean, why would you do that? Like, they also lied to the juvenile court. I mean, the findings are replete with credibility findings by Judge Eisenman that she didn't believe anyone here and that they lied to her constantly. They concocted an entire story about meeting in San Diego and having an affair, and none of it happened that they could prove. And Judge Eisenman is very clear in her findings that everyone was lying to her at all points during this proceeding. So it's a difficult, I agree, it's a difficult case, but it's also difficult to say it's just easy to fix. When we've got admitted gaps, we've got a circumstance that isn't on the up and up. And so it just, I think it raises a lot of questions for all of us to consider.
This is why I started with looking at it from the perspective of the child. Because I agree, a lot of bad stuff happened. A lot of mistakes were made. A lot of bad judgment. He's not disputing that. No one's disputing that at this point in time, that happened. But that's all paperwork. What matters to this child is her family relationships. She thinks he's the father. He has been her father the whole life. What there's no findings of is any abuse, neglect, or mistreatment of this child at all by any of these parties. This is fully on the paperwork.
But we do have a criminal conviction of sexual battery of a child by MC, the father.
There's a
Right,
yes, there's a misdemeanor. He pled guilty to the misdemeanor.
Right.
There's that. That again happened after the custody transfer. So she couldn't have known about that.
It happened after,
He was
I
charged
understand,
after.
I understand the date, he was charged after. But that can't be of no consequence, right, when you're considering
It may be, it may
the
not
best
be.
interests of the child.
But that's why you go through a termination analysis. That's why he should be entitled at least to go through the Termination Act and have the protections of the Termination Act. So the state has to prove that that's consequential to this child because there are no allegations as to this child that there's any mistreatment. She was loved, cared for, and adored. And now she's been separated from family and has a diagnosed attachment disorder. So that's really where we need to be looking when we think about the equities of this case, not just the legalities, but the equities. Yes, a lot was done wrong, but all of that was violating paperwork. But what was important to the child was who her parents are. And that's why we're asking the court
I
to
mean,
reverse.
violating paperwork's a pretty kind way of describing,
And-
you know,
he was
international
prosecuted for that.
child abduction is another way you could describe it, right? Or trafficking. I mean, there was an investigation by Homeland Security here.
And they found no trafficking.
So it's not that this is,
It can be vilified. I agree.
I mean, I think things happened and they can be characterized in a variety of ways. And I guess the question is whether and how they're consequential. And that's what we're all here to figure out.
That's right.
So thank you very much.
Thank you.
I'm sure we'll have lots of questions on rebuttal and you'll have your full time. And we will now turn to Mr. Hackey and the guardian ad litem.
May it please the court, Heath Hackey with the Guardian Ad Litem's office. First of all, I want to start by saying, I think Your Honor, Judge Oliver, you're correct. It's not a very sympathetic case. And I think Judge Eisenman's findings went to that. And the assertion that the child is not at risk in this case cuts against the entirety history of the case and cuts against that there were a lot of facts that the court found that the child was brought illegally into the United States. The father had a history that puts the child at risk, and Eisen went into some depth on those. And so to say that that's not the case and to go further and say that these parents were not found abused or neglected also, I think is inconsistent with the record. But I want to start with the parentage action. This actually is a simple case. It's not hard. Judge Temmie, I want to address your initial concern where you spoke to the UCCJEA, but in doing so, Judge Aller, I want to talk to, because I think it looped in really well, your question that you posed, which was, why establish parentage? Which is an excellent question, because that's exactly what they actually did in this case. They asked the court, if you look at the heading of the pleading that was before the court, was a verified petition to establish parentage. The request for relief was to establish MC as parent. That's what was before the court. The reason that we do that is because you have residual parental rights, right? We all do it. If we're with someone and we sign a voluntary deck, we do that, we establish parentage, and under the Utah Uniform Parentage Act, that's recognized as establishing parentage.
So
We
there's
don't-
there's this question running through the case of what statute we're supposed to be looking at to determine the legal effect, if any, of the Mexican birth certificate. Let me start with the initial question. Do you agree with the suggestion from the other side that to fill in the gap, we should look to the child custody determination clause of the UCCJEA?
No, and that's where I'm going. I'm illustrating why
Fire away.
I'm going there.
Yeah.
So, because it's important to point out this distinction, I think it illustrates it well. If you have a married couple, they have paternity and they have residual parental rights to make decisions regarding medical and so forth. That's why you establish paternity. Custody, which is where the UCCJEA comes in, is a totally different analysis, right? You are involved probably typically during parent time. You have some sort of a division between parents. That's a totally separate question.
So if we're not
And the-
looking to the UCCJEA, what do we look to determine the effect, if any, of the Mexican birth certificate?
Well, as to the UCCJEA, it's our position that it doesn't apply, because what they were requesting in this case is that they establish parentage, and that's an important distinction. And Judge Eisman goes to great length in that, in her opinion about, this is a parentage case, and we're only looking at the Utah Uniform Parentage Act. And so what counsel is suggesting in this case is that we take the Utah Uniform Parentage Act, and I'm gonna answer your question, Judge.
I believe you.
And because it does not have any reference to how we treat a foreign birth certificate, let's apply the UCCJEA, because that's the next closest thing, right? Even though it has no application, it's a custody statute. So then we look to that, well, that doesn't really speak to it, which was also your question, that it doesn't speak to it. So then what do? Well, let's stretch that statute beyond its meaning, and let's start talking about the Hague Convention, which actually is a petition to return the child to the state, which has no bearing whatsoever in this case. There was no petition filed in Utah to return the child to Mexico. And I believe that that's the Mexican law that they were referencing. And that kind of has some semblance to something that's going on here. And we'll look to that because that provides guidance. In so doing, you're taking the actual statute that's on point, stretching it beyond its plain meaning. Because, by the way, absence doesn't mean ambiguity. And I think Eisenman points out in this case very well that there's a significant difference between establishing parentage and custody. Because in a custody proceeding, you've had judicial oversight. You typically have a judge. So if a foreign custody order comes in, the judge here knows there was something involved.
So the provision is what? Let's just go there. In your view, what's the provision that we're supposed to be, what's the phrase from what statute that we're supposed to look at to figure out the effect, if any, of this Mexican birth certificate?
I think Judge Eisman in her order did it. It was silent. And as I said, silent is not ambiguity. The legislature, if they wanted to include provisions regarding a foreign birth certificate.
So if it's silent, are you saying that no birth certificate from any country has any effect here?
No, that's not what I'm saying. So let me clarify that point. And I think Eisman spoke to this as well as.
Judge Eisenman.
Judge Eisman.
Yeah.
She did consider it. They've referenced that it was ignored, but it was not ignored. The court, like anyone else, and we went into, Judge Oliver, you had mentioned, how do we treat this between someone in a different state, right? And I like that question. It wasn't ignored. If somebody from Mexico
So
comes to
what's the
Utah,
provision from what statute that we would look at that would tell us what effect this has?
you would go under the Utah Uniform Parentage Act, and under that, there's certain ways that parentage can be established. So
Is there a way, let me get to the sort of 3 steps down the train
Yeah.
question. Is there a way in your view, in the state's view, or I guess you're the guardian ad litem, is there a way in the guardian ad litem's view for a foreign birth certificate to have legal significance in a parentage action in
Yes,
Utah?
and it did here.
And what's the statutory hook by which that would be considered?
It would be under the Utah Uniform Parentage Act, but it would come in like any other evidence. It's not given additional weight because there's no full faith and credit given to that birth certificate, but it comes in as evidence.
But when another country is involved, the analog, not as familiar as full faith and credit, is the principle of comity, not comity, comity, whereby courts of the United States tend to recognize and give credence to the proceedings and documents that have been generated in another country in accordance with their own customs, rules, and et cetera. I don't know that the principle of comity was argued below or played any role in Judge Eisenman's decision, but that is a not unfamiliar basis by which we tend to give something akin to full faith and credit to the decisions and certifications of other countries.
And I think the judge in her findings did that here. She didn't disregard it. She looked at the birth certificate along with the other evidence, including the evidence from the United States consulate. It wasn't just disregarded or ignored. She weighed it, but the overwhelming evidence, which should be weighed viewed favorably in light of the disputed finding, was that it wasn't valid. And if you, it would be
What do
no
you mean by
different than
that? I
if.
mean, you said that in the brief, and they've pointed out correctly, I think, that nobody has officially invalidated the Mexican birth certificate. Are they wrong when they say that?
I think that yes, I think that that's.
Who and where has invalidated the Mexican birth certificate?
Well, I think that the court didn't recognize the legitimacy of the Mexican birth certificate.
But
And she points to
wouldn't you have to go, if you're gonna invalidate the Mexican birth certificate as a document, wouldn't you have to go to Mexico and invalidate the Mexican birth certificate?
But that's not what they were doing here. They weren't trying to invalidate it. They were asking this court, Judge Eisenman, to establish parentage. They weren't asking to invalidate it, and Judge Eisenman didn't invalidate it, but she wasn't inclined, given all the other evidence that was presented, to base on that establishment.
She's not in, I'm gonna lose the
You go
thought.
ahead.
She's not invalidating the Mexican birth certificate. So what you're saying she did, and I think this is correct, is she's saying, look, it may be valid under Mexican law, but I'm not gonna afford it, to use Judge Orm's point, I'm not gonna afford it comity under Utah parentage law.
Because this statute doesn't require it. Let me draw the illustration.
Which statute though? But
The
we've been
Utah
told.
Uniform Parentage
But
Act.
we've been told by all parties, I think, that there is a gap in the case law, that there is no provision that specifically tells us what to do with the foreign birth certificate.
That's because it doesn't require full faith and credit. There is a provision under the Utah Uniform Parentage Act, and it's 78A 15610, that applies to other states. But even if that applied in this case, which it did, and what that statute says is that the court of Utah will give full faith and credit to a voluntary declaration from another state shall. But it also
But it
says.
seems like a fundamentally different matter. It's one thing to give full faith and credit to a decree birth certificate from another state. They're part of the federation that's the United States of America. But this issue of what to do with some other country's birth certificate feels altogether different to me.
Well, the point that I'm trying to draw is, yes, it is. And what the argument from the appellants is we should actually elevate the position of a foreign birth certificate to that of someone from another country, because that provision 610 actually says that the court shall recognize a birth certificate from another state if it is done in compliance with the standards of this state. So it's not a mandatory. The court still then, so if someone from Colorado came with the birth certificate to the state of Utah and says, I want to establish parentage, I don't have, all I have is this birth certificate voluntary deck, and they ask the court to do it, then the court would look at that and say, okay, now I'm going to take evidence to see, per that other provision of 610, was this done close to what we would do in Utah?
Okay,
And
so-
that's effectively what Judge Eisenman did here.
I think maybe I can solve this. I think we would all agree, and you can correct me if I'm wrong, that the Utah Uniform Parentage Act simply doesn't say what to do with a birth certificate from a foreign country.
That's
Because it's not covered under 610, right? And so because it doesn't say what to do, the MC is arguing that you do need to give it full faith and credit and is looping in through the UUCCJEA, right? And I think what I hear you saying is because the statute doesn't tell the juvenile court what to do with a birth certificate from a foreign country, the juvenile court can do what the juvenile court did here, which was assess its validity, consider it, along with other evidence that it's taking as part of the parentage determination.
That's correct.
Is that correct? Does that
Yes,
help?
ma'am.
That,
Yes, Your
okay,
Honor.
so,
Okay.
And then-
okay, let me
Sorry.
use that then as the springboard for the question. One of the more compelling points I think the other side made in its brief is the hypothetical, and I just didn't really see a response to it, to be honest, from the state's brief, the Guardian, and the Lino's brief, to the problem of what happens to a non-native family, whether they're here on a student visa, worker visa, whatever, but they're here, and DCFS gets involved for whatever reason, and all of a sudden, they don't have a court order or whatever establishing parentage. That seems to put them in a real, I don't know the right adjective there, but it puts them in a difficult position. And that's one of the things they've told us is problematic about your position. I wanted to make sure we got your response to that. Why is that not problematic?
I don't think that it doesn't put them in any more of a difficult position than anyone else. And what Judge Eisenman did here was whether she gave it full faith and credit or not, she did just that very thing. So if someone comes from another country with a birth certificate and wants to, under Utah law, establish parentage, they have to bring forward all evidence. What we're talking about is not, is it ignored? Because it simply wasn't in this case. It just wasn't given added unassailable evidence to even that from another state. The court took it into account, took evidence, and because of all the evidence, found that it wasn't
Doesn't that
valid.
feel a little bit problematic to you, though? I mean, most people, I would think, don't go to the trouble of getting a court order establishing their parentage. And so if you're here and you've got kids and you've got a birth certificate, which is all that most of us have, and then DCFS gets involved and all of a sudden you have to prove parentage, something above and beyond the birth certificate, that feels a little unwieldy in some circumstances, no?
It feels consistent with Utah law. And that's what the court did here. And my problem with the appellant's position is that it basically takes the UUPA, asks this court to analyze it under the UCCJEA. In other words, suing for contract and then faulting the court for not applying property principles. So that's an important distinction between the UCCJEA, which deals with custody, and the UUPA. And it's an important distinction because the relief that they critiqued the court on was saying that she addressed or she answered a question that was never asked. Actually, that was the precise question that they asked the court to resolve. So I understand that it's silent, but the court followed the plain language of the statute. And the issue before the court is, did the court err in doing that? And it simply didn't. It didn't ignore the birth certificate. It took it into account with all the other evidence that was presented. And I would just urge the court that silence is not ambiguity. The court pointed to the Hague Convention, and if the court were to say, if we were to take a position even beyond another state and give foreign birth certificates that we know nothing about. Now, a birth certificate, not a custody order, and we were to give them unassailable credence.
If we're making this up out of whole cloth, which it kind of feels to me like we're being asked to do, why wouldn't we write something akin to the following rule? Why wouldn't we just say that we're going to start with the presumption, at least, that a birth certificate from another jurisdiction that has not been invalidated establishes parentage and work from there? Why wouldn't that be the natural starting point?
Because the Utah statute doesn't allow for that presumption. It's not in there.
I
It's
thought you-
consistent with the principle of comity, though, that we would do exactly that. And it may well be that in this case, that presumption got rebutted, but it seems to me difficult to just ignore a birth certificate from another country that appears to be regular on its face.
And it hasn't been invalidated in
And
that other
hasn't been
country.
invalidated. I mean,
Well,
to
we're
start
all
with that presumption and then see if there's a problem, and I understand the argument here that there most certainly was, but I think it's fair to do as Judge Tenney suggests.
I'm sorry, Your Honor, I didn't know if that was a question.
It was an observation, I
Okay,
suppose.
And
And if I could
noted,
rephrase it, I would have put a question mark at the end,
That's-
because I would be
I-
interested.
In the
your-
transcript,
I
there will be a
understand the
question.
court's concerns, and then I think I'll move on, because I think that it doesn't, because we're asking, did the court in this case err? Was there a legal error? And she simply didn't, based on the plain language of the statute. And I'd also remind the court, going to your question, if somebody comes in, it's still, so the Judge Eisenman applied a belt and suspenders approach, because she said, even if it was valid, even if it was a voluntary deck, which I'm not convinced on the evidence that it was, it's still subject to attack. And in this case, it was subject to attack. And it was subject to attack based on the DNA evidence and all the evidence that the court heard.
So
Yeah.
her analysis would be no different had she taken that presumption that Judge Tenney and I are receptive to. Had she taken that presumption, she would have considered that it was rebutted here.
And that is a question. And my response to that is yes. I think the response is that I think the result would be the same. Because even if she did do that in this particular case, she also found that it was subject to attack under 608 and could be invalidated, which is a basis, is the DNA evidence. Counsel raised the argument that the father had a relationship in this case, but she also weighted that regarding the risk of his sexual abuse, the way in which that child came into the United States, and if we're talking about the present tense, at the time of the action in this case, the child was actually bonded in another home. I understand that there's been argument that the child recognized the mother, but there's also a lot of evidence that the mother in this case, and that was presented to the court, should be viewed favorably, that the mother had no connection in this case to the child. And the court made several findings that the child was actually bonded and doing well in another home. And so under 608, the court properly, based on the GAL's motion, disregarded the DNA. So even if that were the court's position, I think the court still addressed that concern, saying it could be successfully challenged under 608, and I think that that finding was appropriate.
I know you're.
And that standard was an abuse of discretion. I think I pointed that out in the briefing. Some of the counsel had raised what was the legal standard. I do think since they're wearing statutory factors, it's an abuse of discretion.
And I know you're at zeros. We took up a lot of your time, so I do want to offer, if you have some additional points that you would like to
Yes.
make
Thank you, Judge.
in a brief manner, that we would permit you to do so.
Yes, and I just want to speak, I think I can handle I think I've addressed most of my concerns on the parentage. I think the court, between the brief and my comments here today, probably have a good picture of our position. As to the findings regarding the mother, I think the court has a good sense, based on the questions I've heard today, of what the issue is regarding the unregulated transfer. They do raise the issue of the plain error doctrine. This court has not recognized its civil appeals. We still maintain that today. And I think this is a good case to illustrate that, because the court is not in a position to sua sponte raise those kinds of concerns regarding the retroactive application of a statute. And specifically because the judge in this case may well not have done that or objected, because that seems to be their argument. It hinges on the unregulated transfer, and the defense is this was actually a regulated transfer, and so strategically, they may well have withheld that. Now, if Judge Eisenman had posed that question to him, it may have defeated the very defense that they're now proposing to the court. So I don't think it constitutes plain error, even if plain error applies. Secondly, with respect to the grounds, this court can affirm on other grounds. I think Your Honor has raised this. There was some discussion, Judge Tenney, that you had raised regarding 108, and I think your points are well taken. Is 108...
Ms. Marichal told us in response to my question about how to interpret 302.1, that as a matter of course, the courts are regarding that list in 302.1 as these are the means by which you prove abandonment, full stop. Is she right or wrong on that?
I think it's prima facie. I think Your Honor has indicated that the state, it's not that the state has to prove that, it's that the Eisenman's findings amounted to prima facie evidence, which does shift the burden. But to my point on your 1A, I think you were raising the issue of if you provide surrogate care to someone, does that mean that you just don't have to contact? And I don't think that is what 80-4 302.1A contemplates. That's a scenario where in my mind. It doesn't say you don't have contact, because I think that the no contact is also contemplated under the other subsections regarding support, the failure to show the normal interest of a natural parent. That's another basis. So if you give somebody custody of your child, and I think Judge Eisenman's findings amounted to that, and this court can affirm on any ground, if you just say provide surrogate care and full stop contact with your child, and there was evidence that the child had recognized the mother's picture, but that doesn't mean that there's a relationship or that she didn't maintain contact. There was actually substantial evidence that she didn't have contact regarding the child from the date of birth that's in the court's findings. And so it's not just,
How would it be the case, how old was the child at that moment? Two and a half?
that's my, I can't remember.
How could it possibly be true that a 2.5-year-old would recognize a picture without?
Well, that was the evidence that was
Regular
presented,
contact.
that there was some evidence that the child had recognized
Well,
the mother.
A picture could simply be in the home, and they could
Correct.
talk about the picture and show the picture
I
to
suppose,
the child
yeah.
without
But that-
ever having
I guess
seen the
that's my
person
question.
in.
Yeah, and that has to be
Right?
viewed in light of all of the other evidence from the other parties that testified regarding the lack of contact from mother for a period of time. And so it's not just 302A regarding the surrogate care, but it firm on any ground, including the failure to show the normal interest of a natural parent without just cause, which I think there was ample evidence in this case to do that. And there was also ample evidence of neglect, which is failure to exercise proper parental care. There was evidence that she hadn't provided support, that she hadn't reached out. So even if the court, the plain error and the retroactivity of the Utah Uniform Child Custody, the
Unregulated
statute,
transfer,
I'm sorry, a lot of acronyms. Even if that didn't, and the court should have done that, which I don't think she should have, because it may have defeated the very strategy, there were several other bases by which the court could have affirmed and had grounds to terminate in this case. So I think I've answered your Honor's questions. I've taken way more time than I probably should have. I'm open to any other questions if you have them.
I
Thank you.
think we have no further questions, thank you, and no apology needed for going over time. We certainly invited it, and there are ample questions here. All right, we will hear from the state now.
Hey, police court, John Peterson, Assistant Attorney General on behalf of the state of Utah. I think I'd like to start where both Judges Oliver and Tenney have kind of gone. You know, there's a right way and a wrong way to do things, and the formality matters. If you want to adopt a child from Mexico, you can adopt a child from Mexico, but you need to adopt a child from Mexico. You don't drive down to Mexico, find a child, and try and bring it back across the border without any legal right to custody. I mean, it's important. I mean, again, we talked about.
One of the things the other side has argued in response to that exact point is that doesn't really matter to the child. The best interest analysis is supposed to be forward-looking from the perspective of the child. So why does it matter to the child? So here, the child is raised by MC and his wife. The child bonds with MC and his wife. So why does it matter to the child, what you just said?
I'm not saying that what the child believes doesn't matter, but there's a point where things like illegal trafficking can't be justified. I mean, if you traffic a child from Mexico, that child may be very bonded to a trafficker, but you're not going to leave the child with a trafficker. Not everything a child wants will happen. And at this point in time, the child's been in the current foster home since 2022. So there's a quite a degree of bonding there. And unfortunately, did the child get attached to MC and his wife? Probably. That's unfortunate. But is the child attached to mother? It doesn't appear to be. Maybe she could identify the picture as Judge Oliver did, but is that because they just showed her to her every day, said this is Mama A, this is Mommy A, Mrs. Mommy A? The child also had some very adverse and regressive behaviors after seeing the pictures of AMC. So it wasn't necessarily a positive response to seeing her biological mother. But I think that the main thing about this case is that context matters. If this were a case of some Mexican man who had illegally crossed the United States, who is here with his daughter, looking for work, something happens, DCS comes involved, they're like, oh, you're just going to take his child away and say he's not the father? No, we're not. Because he is the father. He's biological. Genetics matter. Genetics is science. MC is not the child's father. AMC is, but this is one of the two cases I've seen in almost 30 years where maternity was an issue. It was not until 2023 that she actually established she was the child's mother. She had Apple on her too. She appeared before. There's a weird thing where she appeared inside a car, and the Judge Eisenman was worried about it because she seemed to be under duress. There's a lot of skullduggery going on in this case. There's a lot of, and this whole case, clearly what was intended is MC went down. However, he came in contact with AMC. He found a woman who was pregnant who did not want her child, and this is a quickie back room adoption. It didn't go as planned because, the consular authorities refused to wanted genetic testing because he was not the father. Again, like AMC why are we not doing genetic testing? Because he's not the parent. I was just giving up to this guy. This is, an arrangement. And to keep backtracking, we file, also there's an intervention by NO, seeking custody, and then when all of a sudden Judge Eisenman starts getting concerned that, that something weird is going on, withdrawn, gone. And then it's months more before, December of 2023, when mother's back in, saying, oh yes, I am mother, 2 years after removal of the child. This is all them trying to figure out a way to do what should have been done right in the first place and was not.
And isn't it mother that filed the paternity action in district court?
It was, in fact, Elsa.
So she at that point, it's after she's been determined through the genetic testing to be the biological mother, that she files the parentage request in district court that ultimately gets consolidated into juvenile court, right? That's the procedure of
Correct.
how we got both proceedings in front of the juvenile court. So as I understand the request, and I can be corrected if I misunderstood it, was that the Mexican birth certificate should have been given full faith and credit, and so the only proceeding that the father should have been subject to is a termination proceeding. At least that's how I understand their top level argument, right?
Yeah, I understand.
But we were never in a termination proceeding here because there was a parentage action filed, right?
Correct.
So help me understand the procedural nature of this. If the parentage action was determined in his favor because of the deference to the CCJEA, then would it proceed to a termination action?
It would have. I mean, I think Judge Eisenman wrote correctly that it's a standing issue. Initially, she's like, I don't think any of you people have any standing to be here because none of you have any parental rights to this child. And so, when you plead, whether it's abuse, neglect, dependency, termination, you plead that this is a child and these are parents or guardians. So that's a fundamental issue. You don't get through the courtroom door unless you're a person who has a legally protected interest in the child.
And so the way that procedurally it came before Judge Eisenman for MC to establish parental rights was through the parentage petition that was filed by the mother because he wasn't genetically related to the child and couldn't therefore assert parental rights in the juvenile court DCFS proceedings. Do I have that correct?
Correct, and then she merged, and it was originally filed in district court, then the district court correctly, that she entered an order, but then withdrew it because it didn't know about what was going on, and correctly transferred it, and they were all merged together. So the first question is MC the child's father? If he's not, then we don't need to decide about, terminating parental rights because he doesn't have any.
Right, so the first question that had to be determined was a parentage question.
Correct.
Right, and as I hear the argument on the appellant's side is that was easy. We have a Mexican birth certificate, sort of period, full stop. He was the father, and so then you move forward from there. And so I guess the question is, on the Parentage Act proceeding, is it the position of the state that the act is simply silent on what to do with a foreign birth certificate, and so you proceed, I think as we discussed with the guardian ad litem, the juvenile court proceeds to consider whatever birth certificate is as evidence among other evidence in making a determination on parentage? Is that how the state?
I believe that is, because there's no clear treatment in the Utah laws of what this, foreign birth certificate, what kind of legal effect it has. But, I think it's important, to also consider what are birth certificates. Birth certificates are inherently flaky documents. Basically, anybody can be on a birth certificate. You show up, mother gives birth, some guy walks in, says, I'm the dad, I'm on the birth certificate.
Let me stop you there. What they're telling us is that as a matter of Mexican law, they are not inherently flaky documents. And one of the driving points of their position, and to be honest, it has some resonance with me, is that I don't know that you can say there's sort of a one-size-fits-all rubric for a birth certificate. A birth certificate in America may well be a different thing than a birth certificate in France, which may well be a different thing than one from Somalia. And what they're telling us, with some backing in the record, is that here are the people that are saying that this is what is required to get a Mexican birth certificate, and it's not just simply a function of signing something that the nurse brings you.
Yeah, I mean, there is some kind of a government, functionary involved, so maybe.
There actually had to be, if I recall right, they had to swear under oath or something to that effect, right?
I mean,
So that doesn't sound like an inherently flaky document.
I mean, other than somebody who's not the child's father can come in and become, I mean, the process is inherently
Okay,
subject
so
to fraud.
one of the things that we've been told is that there's really not, functionally speaking, there's really not much of a difference between what they would have done to get a Mexican birth certificate versus what they would have done to get a court order. Why are they wrong about that? Like,
well,
or
they-
to
I mean-
to put the question a little bit differently, what is it that requiring a court order would have added that wasn't already done under the specific parameters of the Mexican birth certificate
Well, I mean,
process?
a formal, order from a Mexican court that MC is the father entitled to custody of the child is a very different document than merely, this is basically formalizing the parties' statement of their
But
relationship.
what if it were true that in some case, and I don't know if this is the case, and I suspect you're gonna tell us it's not, but what if it were true that in some case we were presented with evidence showing that in country X, Y, or Z, in order to get a birth certificate, you have to go before a magistrate, you have to swear that you're the father, you have to do all these things that we would normally do here to prove parentage in a court proceeding. What do we do at that point? Why wouldn't it be the case that the birth certificate there is the equivalent of a court order?
I mean, it depends on, I guess, how formal it is. I mean, and I think Judge Orr mentioned comedy, and generally principles of comedies are that if things are done in a foreign country in a way which is commensurate with how they'd be done here, then they're entitled to generally more respect and dignity they would be if they were done in some way that we would not do them. But I think at the end of the day, I mean, best case, assuming this is much like akin to a VDP, assume this is akin to a US birth certificate, the issue of parentage is still genetics, with an underlying element of estoppel. I mean, at the end of the day, I mean, there's no debate, MC is not the child's father. Are there contexts where a person who's not the child's father can?
I understand the point you're making. You've made it in various forms several times. It's not purely a function of genetics. There are a lot of people who have no genetic relationship to a child, and they are very much the parent of the child, right?
Correct.
Okay, so what you just said is not true.
Well, I said an underlying element of estoppel. There are cases where people, throughout the years have held themselves out as a parent, and by virtue of I mean, that's why under the Parentage Act, Section 608, there's a reason where the court can disregard genetics if the court finds it's appropriate to do so.
Well, and again, we're not here if this is an adoption that's done appropriately,
No.
right? I mean, there's nothing inherently wrong with MC seeking to become the father of IC here. If done through the proper channels, the courts would have blessed that transaction on the legalities of the paperwork, and MC could have full parental rights to a child with no biological relationship. The issue here is that none of those steps were taken, right? And so we're left with, what do we do where we've got the only evidence to support the parental rights is a foreign birth certificate that's contradicted by genetics? Because again, if there was a proper adoption or there were genetics, we wouldn't be here, right? It's just this combination that brings us here. And then the question is, what is the proper proceeding, at least in my mind, for the court to undertake to make that determination? And, we're being told that the CCJEA, we should look to that to guide us, that Mexican birth certificates are different enough than something that you called flimsy, that they ought to be given, conclusive evidence. And what we have here, it seems to me, is we have an admitted gap in the law that the UUPA simply doesn't say what a court should do when the only evidence is the birth certificate, right? So they've made an alternate argument about a VDP, and I had a question about that I'll ask you as well. They've asked us to in the alternative, consider the Mexican birth certificate as equivalent to a VDP. Do we have the ability to do that? I mean, the statute has requirements. They're admittedly not met here. I'm being told they couldn't be met because there wasn't an underlying US, Utah birth certificate. So what do we do with that? Is it an alternative argument really only in the ether, or is it something that could actually be considered? I'm struggling with what
I think it's
would
more-
we
I mean,
say?
I would say it's more of an alternative argument in ether. I mean, there's nothing under the EPA or the ECJA, sorry, I'm getting initial tied there. But, I mean, that really deals with the recognition of a Mexican birth certificate. But I think the arguments are basically like, best case scenario, let's consider this is something like a US birth certificate. Let's consider this is something like a VDP. The EPA still gives the court the ability to adjudicate paternity. And that's, I mean, and in the end of the day, the gold standard of paternity remains genetics, because it's 99.9 whatever percent perfect. It's, I mean, and there's a very clear result here that happened. I mean, taken to its logical extreme, the argument, that MC and AMC make is that you can go down to Mexico, you can find a pregnant woman, and you conclude with her to do an illegal adoption, and that birth certificate is sacrosanct and can't be challenged. There's nothing we can do about it, and that simply is not right.
I'm sorry, I'm still stuck on that. The gold standard is not just genetics. I understand the point you're making, but the verbiage you're using is really problematic. It's not just genetics. It's either genetics or following the proper procedure, as Judge Oliver
Right,
pointed
yeah.
out, to properly adopt the child. But you've said that in some form 4 or 5 times. It's really problematic, I think.
Right. I mean, the reality, the parentage of a newborn child is a different thing from the parentage of, say, a 10-year-old.
Well, no, you can adopt a newborn child.
can, but-
and you were every bit the parent of the newborn child if you properly follow.
adopt.
I think the point you're making isn't the point you're saying, but the
Okay,
point
yeah,
you're saying
yeah.
is really problematic. I think.
Okay. I'm saying, the questions of genetic identity are scientific. I mean, yes, can you stand in the stead of a biological parent as an adoptive parent? Yes, you absolutely 100% have exactly the same rights if you go through
If
the
you follow the
niceties.
procedures, and your point is they didn't follow the proper procedures.
They did not,
All right, okay.
and which should be fatal to an attempt to do an illegal adoption.
Well, if we did find a way to recognize the VDP, the Mexican birth certificate as an equivalent to a VDP, that still here requires MC to request the court to disregard the genetic testing results because it shows that there isn't a relationship there.
Right.
And Judge Eisenman did that analysis
She did.
below, right? And so, as I understand our review of that analysis, it is a discretionary decision by the juvenile court whether or not to disregard. And I think there was some question on appeal about what the proper standard of review is for that. But if it's discretionary below, what would you say that the review is on appeal for us looking at a discretionary decision of a juvenile court?
I mean, it seems likely that it falls in the general mix. I mean, there's the interpretation of the statute, what has the factors, and that's an obvious question of law. But the actual factual findings about the degree of relationship between IC and MC and their adoptive parents, I mean, those are all the core kinds of factual findings that trial courts make and are entitled to deferential review of their factual findings. And and Judge Eisman, to her credit, made very extensive findings under Rule 608 about all the various factors and about how those did not convince her that she should disregard. And she could have found, what? I understand 100% you are not this child's father, but she loves you to death, and this is really giving me the best place for you. And I'm going to leave it there. I'm going to disregard that. She did not feel that. She very clearly, ruled this is not appropriate and should not be done. I do see I have used my time. If there's more questions, I'm happy to answer them, or I'm happy to sit down.
I don't see any further questions. Thank you, Mr. Peterson.
Thank you very much.
All right. And we have 10 minutes for rebuttal. We'll see how well we stick to
I'm gonna
it. Where
try. Okay.
our track record today, I have to say, is rather abysmal, so.
Some days are just like that. I'm gonna go backwards through the points, hopefully. So I'm gonna start with, when we're looking at the VDP, whether we're interpreting it as the Mexican birth certificate was valid, full stop, or it was a VDP what do we do, like what happens after that, I think is something to be answered. So if we say that the Mexican birth certificate is proof of parentage, then it has to be invalidated in Mexico. There is no Utah statute that allows you to invalidate a foreign birth certificate. If his paternity is established by it, then you have to go to Mexico to invalidate it.
Would that be true? I mean, one of the wrinkles of this case is that Mexico is a neighboring country that, I don't know how to put this question. This isn't a third world country with no organized government, right? And one of the main pitches you've made to us is you can give comity to a Mexican birth certificate, but would you be saying the same thing if it came from some country with a less than robust commitment to scandalous government?
If we didn't have the evidence on the record, if we didn't have essentially a Mexican law expert testifying that, and Judge Eisenman accepted that testimony at 1589, 1590 as true, of this is the process in Mexico, this is what happens, this is the rights it confers. If we didn't have that evidence, no.
But
we
what
would
I'm
not be able
struggling
to do
with,
that.
and I think your answer is going to be the same, but the thing that you said that just prompted that question is, as long as you've got a valid birth certificate from this other country, I can't remember how exactly you put it there.
As long as you have there's a couple
Yeah.
qualifications. I was summarizing. As long as you have a valid birth certificate from a country who confers custodial rights with a birth certificate and whose birth certificate is the process for obtaining it is in substantial conformity with our laws. That's what the UCCJA language requires. Then you cannot invalidate that under, like, UAPA doesn't invalidate.
You'd have to go back, your position is you'd have to go back to the foreign country and invalidate it. And I guess that's what I'm struggling with. It's not hard to come up with hypotheticals in which it comes from some country whose commitment to non-corrupt government we don't trust. And so somebody goes and they human traffic a child from that country. I don't want to name a country out loud. I'm thinking of like two of them.
We got it.
You were pretty safe with Somalia.
Sure, but.
I'm not gonna endorse it.
It was purely hypothetical. But you could go to some country X, Y, or Z, traffic the child, go through its full process, get a birth certificate, and then then Judge Eisenman or Judge whoever is supposed to just say, well, my hands are tied, unless you go back to that country and invalidate it. That feels really unsettling to me.
So I think there may be other, and I don't know all of the statutes on child trafficking, but there may be other ways to deal with that in other statutes. And I suspect there are probably Hague Conventions that deal with this specifically. There's probably federal legislation that deals with trafficking specifically that can deal with that problem. But where you have a situation here where you have a birth parent, you have a biologically related parent saying, nope, he's the dad. The birth certificate
But she's
is correct,
lying.
he's the dad.
She's lying.
No,
She's lying according to Judge Eisenman. She's lying when she
Right.
says that.
Not that he's the biological father, that he's the legal father. She is saying, yes, I acknowledge it, he's the legal father according to what we did in Mexico. Even if, it doesn't matter whether she's saying he's the biological father or
But
not.
based on Judge Eisenman's findings, they lied to Mexico.
Yeah, and you can do that in Utah. Under Scott v. Benson, you can walk into the Vital Statistics Office, lie about being the dad, sign a VDP, and you're the dad. You have those rights under Supreme Court precedent. So the same should be true here. Yes, they lied to the Mexican government that he was, maybe, I mean, it's what Judge Eisenman found. It's what Judge Eisenman found.
Judge Eisenman
Yes.
found that the mother met MC after she was already pregnant. So to the extent that they're telling Mexico to get the birth certificate that he's the father, they're lying, right?
Under Judge Eisenman's ruling, yes.
But you haven't challenged that finding, so that
Nope.
finding, we're stuck with that finding.
We are stuck with that finding.
Okay.
That is true. And that's why this argument is structured the way it is, because it's not about all of the bad acts that happened. And bad acts happen in these kinds of proceedings all the time. Otherwise, we wouldn't be here. So we can't just base it on, oh, well, they acted badly, so they shouldn't have their child anymore. That doesn't make sense for the child. And to get back to how this can work, even if you don't acknowledge the Mexican birth certificate, if you say it's a VDP, yes, then it's subject to a 608 analysis. The 608 analysis here is deficient, however, not because of the standard of review. It is a discretionary standard. However, there are two things. First, it's supposed to be focused on the best interest of the child, and we make a pretty lengthy argument about how this is not focused on the best interest of the child. And second, you have to start from the assumption that that is the father. Here, the court did it backwards. The court used the 608 factors to try to they applied them in a way to establish paternity, not to disestablish paternity, which is what Chapter 6 of the Parentage Act is doing. It's to disestablish, was a challenge to paternity that disestablishes the relationship. So the 608 factors have to be viewed in that lens, which they weren't here because she already had said he's not the dad. So that's the error here. So even if we get all the way down to that alternative
So wait,
reading.
I do want some clarification on that. So
Yes.
looking at 608, it says, in determining whether to, and then it talks about a different way, it says to disregard genetic test results under this section, the tribunal shall consider the best interest of the child, including the following factors.
Mm-hmm.
Right, so all we're doing is disregarding test results.
Yes, but if you look at 1, it's to exclude the presumed or declarant father. So this
And
statute's
he-
assuming there is
And he would
one.
have to be a declarant
Declarant.
father, assuming that the Mexican birth certificate is treated the same.
Correct.
And so, as I understand your argument on the error made below, is that the framework for applying the 608 wasn't starting from he's the dad, this is why he's not, why the fact that he's not biologically related matters.
Mm-hmm.
But it was the reverse?
Right. It was, he was using the factors that he has to prove that he should be dad, which is just the reverse analysis. It's applying the presumption backwards is kind of the best way to put it. It's not a clear presumption in the statute, but the way the analysis works. And I think we described it in the briefs as an embedded legal error. Those factors were argued substantially during trial. So that's kind of the heart of what was argued at trial. Absurdity, I'm sorry, I'm going like all the way through. Absurdity can resolve a gap. There's a second case that does exactly that, and it's the last part of it is Daggett School District, Anderson v. Daggett School District, 2023 Utah App 76 at paragraph 29. And I apologize, these were not in the briefing, but in review, I found these cases. There, the court did apply absurd consequences to resolve a gap in the statute and just silent as to what you do with a certain
I know
proceeding.
that case, yeah.
Yeah, so it can be done, is what is the point. It can be done and should be done here to resolve that ambiguity. I also want to go to what the Guardian was talking about. He was citing, I think, 610, it's 310. 78B 15310 is the provisions of the Parentage Act that gives full faith and credit to paternity determinations in other states. This is the one that this juvenile court spoke about and said, well, this is not another state, this is another country, I don't have to apply this. So that's why the state-country divide is really important for the Parentage Act. But the comedy point that Judge Orem made and that Judge Tenney picked up on is kind of a mirror image of what we're asking the court to do with the UCCJA. We're providing comedy to a foreign birth certificate that substantially complies with the way we view parental rights, how they should be established. It is very similar. That was borne out in the testimony that Judge Eisman did accept. So that's kind of a mirror image version or a similar way to get at the same point, which is you should fill the gap in the statute with allowing birth certificates of this caliber, this proven caliber, to function as proof of paternity for these purposes. And I want to remind the court that this isn't resolving this case. Even if this court says, yes, he was father, there's just more proceedings that have to happen. We just want the chance for him to have all the procedural protections and frankly, for this child to have the chance to have all the procedural protections attached to his parental relationship, which was a very real parental relationship for this child. This is what has been argued since the beginning of this case in the parentage petition that was filed by mother, which was only filed after the juvenile court denied standing. So the first argument was we have standing. Juvenile court said, no, you don't. But if you think you do, you can go file a parentage action. So then they did. And in the parentage action, they do not cite the Parentage Act. They only cite the UCCJA. So this has been the tact all along, was to say, no, he's been dad the whole time. He still is dad. At the very least, he was dad in Mexico in 2019. So for sure, mom didn't do anything wrong because she handed the baby to dad. And that's really what we're getting to at the end of the day is whether you believe that the Mexican birth certificate establishes him as dad now is actually not even consequential to the question of whether mom did anything wrong, because it almost certainly made him dad in Mexico in 2019, which means she did not abandon or do an unregulated custody transfer, even if that act applies. So at the very least, this child needs to be returned to her mother in Mexico, which, by the way, Dad is fully supportive of at this point in time. So they are fully aligned on this. This is why I'm arguing both sides. And that makes this situation a little bit different than, say, a child trafficker, which he is expressly not. So for those reasons, unless there's other questions about this, we ask this court to reverse both orders, but at least one of them, depending on which argument is most compelling to the court. Thank you.
All right, thank you, everyone. This is an unusual case, I think we can all agree, and we appreciate your patience with our questions and willingness to engage with the court. We will take this matter under advisement and issue a decision as soon as we are able to do so. And with that, we will go in recess for the day. Thank you so much.